Pretrial Motions 1. The first set of pretrial motions, and this is as review, is motions addressed to the face of the pleading. Motions addressed to the face of the pleading are those sets of motions can be used by either the moving party or the responding party when there's something wrong with one of the motion papers. Whether on the face of the pleading there's a flaw somehow. So whenever you address it on the face of the pleading, you're talking about somehow there's a flaw present and it has to be corrected. The first of these is a motion for a more definite statement, or a motion to make more definite. This is when the plaintiff or the defendant responds in such a way that the other party's unsure of what they're actually saying. You need a more definite statement. For instance, if the plaintiff in the complaint says the defendant has caused him all sorts of harm, the responding party, defendant, might want to say, listen, I need a more definite statement. I need to know how I harmed you. So you would send a motion for a more definite statement, in this case to the plaintiff, and also a copy to the court to keep the court informed of what's going on. By doing so, you clarify your position or the other party's position as the proceeding continues. Another type of motion addressed to the face of the pleading is a motion to strike. This is when one of the parties in their response or in their claim includes materials that are considered unnecessary for the prosecution of the case. I'm not talking about criminal prosecution, I'm talking about carrying out the case. So any type of issues that are unnecessary or scandalous or prejudicial, you know, used purposely to hurt the other side or to make statements that are not appertaining to the case at bar. For instance, if one party was to say, you know, I'm claiming that you've harmed me and this shouldn't be a surprise because you've harmed so many in the past. This is a prejudicial statement, or it could be considered scandalous, right? So the other party, the one that's being victimized by such statements, would file a motion to strike. Again, copy to the judge, copy to the other party. The judge would have to approve this motion to strike. The judge has to approve all these motions. Okay, but it at least sets up a flaw on the face of the pleading that would harm one of the parties. So it hopes to correct that. Another type of motion addressed to the face of the pleading is that allegations be separately stated. For our first example, where I said you've harmed me somehow, harm can take various guises. It could represent itself in various ways. So you might, besides filing a motion for a more definite statement, file a motion that pleadings be separated, so that you could argue, yes, you've harmed me physically and X, Y, and Z. You've harmed me mentally. You've harmed me financially. You've harmed me at my workplace. I've lost wages because of you. Whatever the claim is, you're allocating them separately. You know, like a lunch list, if you will, or like a bulleted list. Okay. The final motion addressed to the face of pleading I want to consider is a motion to quash. This is when one of the parties has not followed proper procedure, civil procedure in this case, and has not given the other party adequate time to respond, or has nail and mailed or left and mail at the wrong address, or the got you type of procedure. Obviously, this has to be ruled on by the judge as well. And if a motion to quash, let me back up a bit. If the judge feels that one of the parties is trying to use that gotcha type of technique, you know, to get the other party, the judge might find with the motion to quash also ending the trial, which prejudice against the party that was doing it. Typically, if there isn't that heinous aspect to it, if one of the parties isn't trying to play gotcha, the judge will merely accept the motion to quash and might even allow one of the parties to refile, giving the other party adequate time. So it's a way on the face of the pleading to correct any improper service of summons and complaint, or improper service of some other motion paper. Okay. Let's move on to the second set of pretrial motions. And those pretrial motions are regulatory motions. Regulatory motions are motions as a set that seek to not address the problem with or flaw in the face of the pleading, but somehow change the course of this, in this case, civil procedure. The most famous of these regulatory motions is a motion for a change of venue. Obviously, venue is a choice by the judge, the court system, of where it is best for the case to be heard. In other words, you can make a motion for change of venue if you feel like most of the evidence or the witnesses can be found in location Y instead of the current location X. So you would file a motion for change of venue. Normally, especially in criminal cases, you hear a motion for change of venue come up when you feel by holding the trial in location X, the defendant would be unduly prejudiced by the populace, by the society. Like there's been too much undue press about the case that you couldn't draw a significant prejudice-free or bias-free jury from the pool of individuals within that society, in that community. So you would file a motion for change of venue. Notice what I'm doing here. We're not addressing a flaw in the face. The face of the proceeding is correct. It's just not in the right place, perhaps. It has to be regulated, meaning moved out to another location. Another regulatory motion is a motion to consolidate or sever actions. This is normally used when one litigant might have several cases against the same defendant. And say, for instance, there's 3 cases of cars being shipped that were water damaged because of Hurricane Katrina or something. Instead of having 3 separate trials for 3 separate civil cases, you could file a motion to consolidate actions. Meaning, you know, since it's the same parties involved, let's consolidate the actions and have the trial concerning all 3 cars. Equally, if, for instance, there's grounds on which that the claims together do not make sense, they do not hang together correctly, you can make a motion to sever actions. Where, for instance, say one of the car cases, it was under Ford warranty for damage or pre-shipment damage or something, and the other 2 were under Chevy. You could motion to sever actions if it makes sense to do so. So a motion to consolidate or sever actions is just that. It combines claims by typically the same parties against the same other parties, or to sever them. Now, if you have multiple defendants, you could file a motion for separate trials, meaning it would make more sense, instead of multiple trials being held simultaneously between a singular plaintiff and multiple defendants, and this is usually done in terms of justice, it would be best to separate trials out, allow individuals to have their own day in court instead of sharing a day in court. If you remember the Menendez trials with the 2 boys, they initially were given 2 separate trials, and then the second retrial was where the trials were consolidated instead of separate trials. So again, it's an issue of fairness, it's an issue of judicial efficiency and the like. But a motion for separate trials is just that, to separate out the various cases and the like. Now, motions is one large set, and those are called motion to amend the pleadings. This is used quite fluently in the American juridical process. A motion to amend the pleadings is just that. As long as if there's a mistake somehow in any statement, factual statement, not in the pleading itself, but in some statement that's made, that's a mistake. For instance, you are bringing a suit against 3 individuals, X, Y, and Mr. Black, and you find out later it's actually not Mr. Black, it's Mr. Brown. You would make a motion to amend the pleadings to change the name from Black to Brown, or from whatever. A motion to amend the pleadings is to correct problems or mistakes that both parties may make. Now, again, it has to be accepted by a judge, and normally is. And the other party, again, has an additional 20 days in which to respond, because a correction of a problem might pose another evidentiary issue for the other party in the opposition. So, motion to amend the pleadings is just one large general set of pretrial motions, just one collective, if you will. And it's to correct problems, typos even, things like that, things as simple as typos. Typically, when the judge has accepted a motion to amend the pleadings, the other party is given 20 days. Again, the 20 days argument each time. Okay? Pretrial motions I want to look at with you are the collective actions known as dispositive motions. These are the most virulent. These are the strongest of all the pretrial motions because these motions can actually end the case. Obviously, I said with the motion to quash, the judge might. But in dispositive motions, if accepted, the judge will end a case. So these are your, how would you say, collateral attacks, if you will, your major attacks on a pending case. Okay. The first of these is a pretrial motion to dismiss. In some jurisdictions, these are called motions of Demurrer. Okay, depending on which jurisdiction. Okay. Here is the definition of the grounds on which to issue a motion to dismiss. You grant a motion to dismiss if there's a failure to state a claim upon which relief can be granted. Failure to state a claim upon which relief may be granted. In other words, you lack either in personam jurisdiction, in rem jurisdiction, or there's absent a party that should be in the case. In other words, you've claimed 2 of the 3 people that should be in the case to bring action against the first 2. You need a third party, in other words, named to complete the action. So pretrial motion to dismiss is a failure to state a claim upon which relief can be granted. Now, as we know from long ago, courts can hear cases in equity and law, ex equo bono. So the question is it bad law or bad facts? And in the case of the pretrial motion to dismiss, the dispositive motion is bad law. In other words, if there's no claim upon which relief can be granted, or if you lack in personam or in rem jurisdiction, you've got a legal problem. Okay, not a factual one, but a legal one. Okay. Demurrer acts the same way. It's like a motion to dismiss in that both the defendant is asking for dismissal of the case because the plaintiff has insufficient grounds on which to proceed. Insufficient grounds on which to proceed. It's saying the same thing as a pretrial motion to dismiss. Okay? The other type of dispositive motion, and it's one that we've seen time and time again, and I kept skipping over it, saying, well, we'll get to it, we'll get to it. Well, now we've gotten to it. And that's the motion for summary judgment. Party, typically it would be the defense, would file a motion for summary judgment with the court if they feel that the pleadings, and this is the definition, on their face, the pleadings on their face, state a cause of action, but there is no genuine issue of material fact to be tried. There's no genuine issue of material fact to be tried. Okay? Going back to what we said before, while a pretrial motion to dismiss is bad law, the motion for summary judgment could be considered bad facts or insufficient facts for a trial to go forward. Okay? So there's 2 ways to bring a dispositive motion. If you feel the party has stated bad law, or it's been the wrong area, you're lacking jurisdiction, you would file a motion to dismiss or motion for demurrer. If you feel like they filed it correctly, the law is correct, but factually they have no grounds to stand on, then you would file a motion for summary judgment. All right? And we'll see this law versus facts thing one more time when we look at grounds for appeal. Okay? Now, moving on. That's our pretrial motions I want to deal with. And sure, there's a slew of others, pretrial motions out there. But those are the ones I want to deal with initially. Major event during this pretrial motion, and that's pretrial activities and discovery techniques. Civil procedure is very different here than criminal procedure, in that a lot more evidence is allowed in. In criminal procedure, only evidence that can be proven to be important to the rendering of a decision in the case is allowed in. Civil procedure, the door is left much more widely open. Okay? Civil procedure requires disclosure of all evidence material and necessary in the prosecution or defense of an action, regardless of the burden of proof. In other words, all material that might be considered, all evidence that might be considered material and necessary, which is much broader than you'll see when we get to criminal procedure, okay, where they have to pass the much greater litmus test, if you will. If you feel that any of the material that's being requested of you as a party is inappropriate, for instance, you have a insurance claim, a car insurance claim, and they're asking about your sex life, for instance, and there was no proof that you were doing anything wrong in the car, then you would file a motion of protective order. This is an additional motion paper if you feel the discovery technique or the materials asked for go beyond that appropriateness. All right. So let's look at just some of the pretrial activities and discovery techniques. The first of these, and the most common, are depositions on oral examination. These are commonly known as EBTs, and the reason why they're called EBTs is they're examinations before trial. Examinations before trial. The more legal term is depositions on oral examination. Okay? When you get a deposition upon oral examination, you're served notice upon your attorney for the party to be examined, and you set forth a date and time and place of the examination. Okay? It must be at least 20 days prior if physically served, and in this case 25 days if served by mail. That allows for the mail to arrive. So what happens literally in a deposition on oral examination is you, perhaps your attorney, the other party you want to examine, their attorney, and a stenographer basically meet 20 to 25 days after the request in a room. Usually it's in the courtroom. It could be any kind of other public building. It could be in one of the law firm's offices. And you sit down, you ask a series of questions. And then after the answers are made and clarified and the like, you sign off on it. And this is evidence that can be brought in court. A deposition on oral examination is used basically when each party is trying to understand what the other party is claiming, what proof they have, and the like. And that's why courts typically like it, because they're actually, it clarifies a lot of the issues involved. And at times it also helps perhaps even settlement prior to it coming into court fully, you know, while it's still in the motion stages. Okay. A similar technique to this is known as written interrogatories. Written interrogatories. Don't pay attention to the thing below. We'll get to that in a moment. But written interrogatories. This is a list of questions that are submitted by one party to the other. A list of questions. In other words, and you'll see in a moment why, you have a list of questions. Again, you're given 20 or 25 days. Instead of meeting someplace, the other party merely has to answer the questions, sign it, sworn statement, it's under oath, okay, and it's sent to the party that's asking the questions, okay, because it's an affidavit of law as well, just like the deposition is, the written interrogatories are. Now, typically, written interrogatories are used in negligent tort cases. That's where you find written interrogatories and not depositions and oral examination. And the reason is quite simple. Negligent tort cases involve a series of, as we know, potential but-for issues. You know, well, if this was happening, well, did this happen? And if this happened, what speed were you going? Or what did you think of next? Or did you see this? And if this and this occurred, then what about this? So whenever you have this type of causal chain of questions, it's best handled by written interrogatories. That way it's not glossed over as it might be if the deposition on oral examination is done incorrectly. There's a series of questions being asked of the party to clarify. All right. Third, and it's already up there because I screwed up the lecture outline, it's a production of documents and things and entry on land. This is normally referred to as a subpoena ducis tecum. Subpoena, S-U-B-P-O-E-N-A, ducis or duces, D-U-C-E-S, and then tecum or tecum, T-E-C-U-M. Literally it means show up in court with the things. Okay? A subpoena, when you normally say a subpoena, you say you, person, show up in court. But a subpoenas ducis tecum is when you require materials to be presented in court. Okay? Now, when you ask for production of documents and things, items, right? You're normally talking about x-rays and perhaps deeds or wills or some other document or thing, literally. Okay, it's teamed up with a notice to admit. So when you ask for a production of documents and things, and perhaps entry on land where they can take photographs and the like, you ask the party to team it up with a notice to admit, admit, A-D-M-I-T, meaning the validity of the item being presented. So that, for instance, if you say, here are my x-rays, and yes, they are the valid x-rays of my sternum or whatever, you're admitting the reliability of the item being produced under the subpoenas ducis tecum. Okay. Couple other discovery techniques include the pretrial conference and stipulations. This is quite like the deposition on oral examination, except it's a more far-wielding type of interview. You typically have both parties and their attorneys in place, and there's a discussion, one side to the other and vice versa. And at times what the parties will ask for are stipulations, meaning, well, we'll agree not to go forward with negligence, and we'll just say that there was a strict liability if you admit to the following, if you stipulate to the following. And this is a way for the parties to narrow the legal issue before the court. Again, the court loves these, simply because they help their work. So when you boil it all down, you're down to one issue for the judge and or jury to hear and find for. So when you have a pretrial conference, you're typically asking for stipulations from the other party. Statements that they will concede to something if the other party concedes to something. These stipulations are also known as requests for admissions. Okay? And finally, ones that you see all the time, especially in those police shows, physical and mental examinations. You could ask the other party to submit themselves for a physical examination. If you say, I've supposedly harmed you, then fine. If it's physical harm, I want to get those x-rays if you don't have them already. I want the testimony by the person who supposedly examined you. And these are also accompanied by a notice to admit. These are used typically when you don't need the person to come directly into court as an expert witness. You just want the other party to submit to physical and or mental examinations if they're claiming that there's some type of harm in that regard. All right? So those basically are all of our pretrial activities and discovery techniques. Coupled with the pretrial motions, you could see how the procedure could take some time, and there's various steps along the way. Obviously, always giving them 20 to 25 days or 30 days if outside of the state to respond. Okay. All right. Let's take a look now at the civil trial steps and evidentiary techniques. And you'll notice right away that the civil trial is much different than the criminal trial in not only the level of evidence, but also other items. The first is the guilt of the defendant. In criminal trials, we all know it's beyond the reasonable doubt standard. Criminal trials, the evidentiary level is beyond reasonable doubt. In the civil trial, the evidentiary level is preponderance of the evidence. Now remember, we're allowing a lot more evidence in a civil trial than a criminal trial. And that's purposeful because the penalties are much less in a civil trial than they are in a criminal trial. Okay, criminal, you're talking about times in jail and potentially execution. Civil trial, you allow more in, and the guilt level of the defendant does not have to reach the high level of beyond a reasonable doubt, but merely preponderance of the evidence. Now, when a civil trial is ready to go to trial, when you're done with the evidentiary techniques of discovery, and you're done with all the other different motions that you felt needy at the time, one of the parties will file what's known as a notice of issue. A notice of issue, ISSUE. A notice of issue basically states that they are ready to go to trial. Normally that's then sent to the other party and to the judge, and the other party, if they're ready, will also file a notice of issue. The first thing you will note in a civil trial are, if there are any jury trials, which are much less likely, the jury only has 6 jurors on it. Okay, and for a verdict against the defendant, all you need is 5 of the 6 jurors. You do not need a unanimous vote, as you would, for instance, in many criminal trials. So you have 6 jurors in a jury trial, if in civil, and only 5 of 6 needed for a verdict. All right. The trial begins with opening statements, and typically it's the plaintiff, since he or she has the burden as the moving party. The plaintiff has to make the opening statement. Basically, the plaintiff will make an opening statement, lay out their case, and then go on to present their case in chief after the opening statement. Some jurisdictions, it depends, the plaintiff will make the opening statement, and then the defendant will make an opening statement or defer their opening statements until after the plaintiff has made their case in chief. Case in chief, what on earth am I talking about here? Well, basically it's this. It's the concept that this is where you make all your factual determinations. This is where you make all your arguments and your proof. Your opening statement is merely giving out your case, the very things that you're going to prove. Your case in chief is actually proving them, showing the proof that you have in the case in chief. Now, after the opening statements, you then move on to examination of witnesses. If you do bring people in, witnesses, they could take one of 4 types of examination. The first type is direct examination. These are questions by friendly counsel, meaning this is the prosecution or the moving party, you shouldn't call them prosecution, the plaintiff's party bringing in witnesses on their behalf and asking them questions. Or the defense bringing in witnesses on their behalf and asking them questions. So direct examination are questions by friendly counsel. Okay? It is key here that during direct examination, whether it's by moving party or responding party, the counsel may not use leading questions. And a leading question would be something where the lawyer, instead of the witness, is actually testifying. Okay? The only type of quote-unquote lead that could be used is it true your name is such and such and that you live at such and such and you work at such and such? Besides those 3 key factual issues, everything else is considered leading. Okay? So proper question would be, well, what did you see next? Instead of saying, well, then did you see the other car crossing the median at that point? That would be considered leading. Okay? So you merely want, in direct examination, the witness to come forward and submit to the court the facts, what they saw. Okay? Then that same person is normally cross-examined. These are questions posed by the counsel who do not produce the witness. In other words, these are defense questions to plaintiff's witnesses, or plaintiff's questions to defendant's witnesses. Okay. Normally, adversarial counsel uses cross-examination to discredit the witness or discredit the information that they are presenting. And to that end, in cross-examination, you could use leading questions. For instance, it says, well, you said in direct examination that you saw the car careening across the median at that point. Isn't it true that you were too busy talking on your cell phone or dialing on your cell phone to see the car coming across the median? So you would try to discredit the witness and or their testimony in cross-examination. That's usually followed by re-examination, right? Same person is in the stand, and then what's happening is they're being re-questioned by the attorney that presented them. In other words, after opposing counsel has asked them questions, tried to tear them apart, redirect examination tries to build them back up again, saying, isn't it true that you did see it cross the median because while you were on the cell phone, you made the simultaneous statement to the person on the other side that you saw them, and then you would produce that witness. You understand? You tried to reestablish the credibility of either the witness that you brought forward or what they had witnessed, the facts that they had witnessed. Finally, you would have a recross. Again, this is tearing down the information, where you might say, yeah, well, you might have said that. Isn't that after the fact, given the time of collision was, you know, 3 seconds before you made that statement to the person because the call didn't complete or something? What you're trying to do again is, by opposing counsel, is tear down the person. So let's look at the witnesses again. Look up at the screen. You'll see direct examination, submitting the information of the witness. Cross-examination, tearing down the credibility of that information. Redirect, trying to reestablish it or strengthen it. Recross, trying to tear it down one last time. Okay? And that's basically how the trial goes. First you have the opening statements, opening statement by the plaintiff, opening statement by the defense, and then the case in chief, which includes the examination of witnesses, and then the closing statements is the last stage of the civil trial. Normally, it depends on the jurisdiction again. The plaintiff and defendant repeat the opening statement pattern. In some cases, the defense is given the last chance to make their closing argument. In the other time, it's the plaintiff. But it depends on the type of trial and jurisdiction. But for our purposes, closing statements are then made. That's all we need to know. What follows is a charge to the jury. And the jury is charged by the judge. This is what the jury needs to do. It's being told by the judge what they need to do before they retire as a jury in sequester to make determination of guilt or innocence. In other words, it's left to the jury to apply the facts. And what the charge usually involves is the judge making legal statements that if you find for negligence, you must find the following in the facts given. X, Y, Z, Z, whatever, okay? If you do not find that, you might still find an intentional. But to prove intentional, you must see in the facts the following. So the charge to the jury is basically the conceptual or legal framework, and it's then the jury's duty to then attach the facts as they see them to those standards to see if those standards are in fact met. Okay? The jury comes back in and hands over the verdict to the judge, and the verdict is then rendered by the judge. The verdict can be either general, special, or general with answers and interrogatories. In other words, when the jury when the jury was charged by the judge, he might have given them a set of questions. Have you found the following? Have you found the following? So that the verdict would basically be the answers to those interrogatories. That's what we call general with answers to interrogatories. Or it might just be the simple question, do you find the person guilty of negligent tort or not? Right? Could be special. If you did find them guilty of negligent tort, did you find their behavior to be reckless, or did you find it to be just simple negligence? You know, so the verdict can take one of different forms depending on how the jury was charged before they were sequestered for the deliberations. Okay, now the trial's not over yet because you have a couple of attacks to the verdict itself. And the first of these is a motion for directed verdict. We've seen these in a couple of the cases before us. A motion for directed verdict is made, and here's the definition: when the party feels that the verdict is contrary to the weight of the evidence. Contrary to the weight of the evidence. When the verdict is contrary to the weight of the evidence. Okay? In other words, let's go back. We can find two problems with any case, a legal problem or a factual problem. In a motion for directed verdict, the problem is a factual one, that the verdict is contrary to the weight of the evidence, contrary to the weight of the facts presented. And if you feel that, you as the party would make a motion for a directed verdict. Alternatively, here's the famous JNOV that you've seen in some of the cases, judgment notwithstanding the verdict. This is made, and here's the definition, when the party feels that the verdict should be set aside as a matter of law. Should be set aside as a matter of law because it was unreasonable. The verdict is unreasonable given the facts presented, or there's been a misapplication of the standard of law. It's unreasonable given the facts given, or it's a misapplication of the standard of law. For instance, if the judge improperly charges the jury that you can find intent if one of the parties was merely negligent, that's a misapplication of the standard of law. Okay? And you would file a motion for judgment notwithstanding the verdict. Now typically, if the judge improperly charged the jury, they're probably going to deny this motion. But the nice thing is denial of this motion is a ground for appeal. Okay? It's a very quick ground for appeal. Because then what they do is, on appeal, they reopen the case and take a look at the charge for the jury and see, obviously in the example I given, that negligence, mere negligence, is not grounds for proof of intent in tort. Okay? So obviously it's the incorrect charge to the jury. Okay? The trial is now done at this point, barring any of these post-verdict motions. Civil appeal. Okay? The appeal can be taken as a right up to the appellate division in most civil cases, unless the judge has basically ruled against your party with said that you cannot take it any further. Okay, that's usually unlikely. You could take it up as a matter of right to the appellate division in the state of New York, especially using the example. But to take it any further, to take it up to the Court of Appeals, the highest court in the state of New York, the case must present some form of constitutional law. And when we see constitutional law here, we're saying the Constitution of the state of New York. Okay? Constitution of the state of New York. Now, let's assume that we've taken it up on appeal. There's two ways to attack the appeal if you're the responding party to the appeal. And the first of these is res judicata. Res judicata. This is also known as claim preclusion. Claim preclusion. Okay? When you're arguing that the legal claim that's being brought up on appeal has already been judged. The claim, the legal claim, has already been judged by the lower court. And when you say something is res judicata, you're arguing that it should not be judged again. Because here's the simple fact, ladies and gentlemen. In a civil trial, the court of first instance is the typical trier of facts. Anything beyond that is the trier of law. factual issues are typically not presented on appeal. So res judicata is a typical way to attack a higher court, a court of appeal, from listening to an appeal, because it's the jury that's at the lower court that has tried the facts, and or the judge, right? So it's claim preclusion. You're saying that it's already been decided by the lower court. It should not be decided again. It should not have been listened to by this court. The other possible attack on an appeal is known as collateral estoppel. Collateral estoppel. This is also known as issue preclusion. Issue. Remember, we said before, you get attack on facts or law. Res judicata is the attack on the law. Collateral estoppel is attack on the facts. Okay? When the litigant bringing the appeal is trying to retry the facts of an issue. That's why it's an issue preclusion. You're trying to preclude the litigant from retrying the facts. Okay? So it's known as collateral estoppel or issue preclusion. And those are two ways to attack an appeal. Okay? Okay. I now want to turn to criminal procedure. Now that we've laid out civil procedure, I now want to lay out criminal procedure. And as I said on Monday, many of the same steps are in the criminal procedure as you find in the civil. But let's look at criminal procedure generally. Okay. First of all, in pretrial considerations, you have the addition of the grand jury. Okay? Grand juries are typically found anywhere east of the Mississippi. It's kind of strange how in criminal procedure it's broken down by east versus west of the Mississippi for some reason. Obviously, it's a jurisdictional issue. It has nothing to do with mere direction. It has to do with how the state jurisdictions were set up. But in the informational pretrial stage, we have grand jury stage. Okay? Where the case in criminal law might be brought to a grand jury to determine whether they should go forward. Okay? Whether they should go forward. A grand jury finding that they should go forward is not a conviction. It's nowhere close to a conviction. It's just basically saying that they feel that they have enough legal facts or enough facts of law and facts of law. They have enough grounds on which to bring the case forward, okay, to trial. An additional stage is the arraignment stage. This is a unique second step in a criminal trial procedure. This is where you bring the defendant in and tell them what they have done wrong, or what they are being charged with doing wrong. That's a better way to say it. What they're being charged with doing wrong. In other words, it's an informational stage directed at the defendant to make them aware of the severity of the potential charges against them. Okay? An arraignment is key because it clarifies exactly for the defense attorneys and or the defendant what they're facing in terms of potential penalties and the like. Okay? In the trial procedure, there's much, much, much more weight given to the jury selection. And we talked about this when we looked at common law, but the entire voir dire process is much more consideration is given in the criminal trial procedure than the civil trial procedure, simply because there's a greater penalty in criminal, right, including incarceration and or death penalty, and more so there's a potential of maybe retribution or a society that's got it in for the defendant, more so than just a mere decision in civil, you know, who was negligent or who breached the contract, you know. So the voir dire process is much more emphasized in the criminal procedure. Okay? Now, trial and examination of witnesses. The permissible evidence is much more restrictive in the criminal trial, as we mentioned before. Okay? The examination for witnesses, the charge to the jury, everything is much more scrutinized, much more restricted. Okay? So the trial, the evidence, the examination of witnesses is much more restricted in a criminal trial procedure than in a civil trial procedure. Okay? One additional step is a pre-verdict step, and it's known as the pre-sentencing report. This is where, again, like the arraignment, after the verdict, after the jury has come back and rendered their decision, a pre-sentencing report is to bring the defendant in to tell them what their potential sentence might be. Okay? So you bring them in, you sentence them eventually, next step. Pre-sentencing, you inform them of the potential sentences. Then the judge sentences them. And of course, you always have the possibility of appeal. Okay? So again, pre-sentencing report, more informational. The sentencing, where the judge officially tells the defendant exactly what their sentence is. And then you have a potential for appeal. Again, there's probably more allowance for appeal in criminal than in civil, simply because the penalties are far greater, right? Including death, execution. Procedures and some pretrial motions. We're not going to go through all of them, and I'm going to go through them very quickly because they basically do the same type of things. Pretrial motions would include such things as motion to dismiss. This is where there's a failure to state grounds on which to proceed. Okay? You would file a motion to dismiss. This is very strong. This is your nuclear option, because if approved by the judge, this ends the potential criminal trial against you. It ends everything. The motion to dismiss. Failure to state a claim upon which relief can be granted. In other words, you got the wrong person, you got the wrong law, there was no criminal violation, however you want to put it. Okay? You have a motion for a change of venue. We've talked about this before. Here, much more, the emphasis is on how prejudicial is a potential jury pool. Okay? But also, judicial efficiency arguments. Where can most of the where can most of the witnesses be found? Where is most of the evidence to be found? Okay? An additional motion that you don't find in civil, but you find in criminal, is a motion for a bill of particulars. This is most closely aligned with a motion for specific allegations. Here is where, when you claim under civil specific allegations, in criminal you ask for a bill of particulars, meaning how specifically or what specific crime or crimes did they commit. This is where you separate out attempt from completion of the crime, conspiracy, parties to the conspiracy. So you motion for a bill of particulars, exactly what potential criminal charges are against the individual. Okay? So in civil, it's kind of like a motion to separate allegations. Here it's known as a motion for a bill of particulars. Okay? Every stage of discovery, and of course discovery is much more restricted. We said that already. You have to file a motion for discovery. The one side must ask the other side first whether they can produce the material, and file that with the judge. These are typically a struggle, more than civil, because civil you're allowed practically everything, right? But in criminal you're not. It's far more restricted. So each of these motions for discovery are a contestable issue, much more in criminal than any type of discovery techniques would be in civil. Okay? Any types of material that are ill-gotten, there's a new word. In other words, any materials that are in violation of procedure. For instance, I can't get the confession, but if I apply the thumb screws, I get the confession, right? If that happens to your client, you would file a motion to suppress, meaning that it was an illegal or improper procedure that was used. If the police come without a warrant and search and grab materials, you would file a motion to suppress. If you applied threats and didn't tell them their rights upon being arrested and questioned, you would file a motion to suppress. And you know this from the criminal show, so I don't have to spend too much time on that. Okay. Now, let's go back to suppress and look at the exclusionary rule. Okay. this is where we get the motion to suppress. Any materials that are gotten from an illegal procedure, anything that's in violation of procedural due process of the individual, is subject to a motion to suppress. Okay? So the exclusionary rule would kick in, and that's appertaining to the Fifth Amendment, obviously. Because who is the moving party in a criminal case? The answer is the state. The state is the plaintiff. They carry the burden of proof. They cannot shift the burden of proof by forcing materials from the defendant, right? They can require materials from the defendant that's legitimate, but, they can't demand confessions through torture. That would be a violation, obviously, pretty clear violation of the exclusionary rule. Okay? Now, related to this issue is, of course, the Fourth Amendment, the search and seizure amendment, if you will. Okay? I like to call it the search syllogism. And the way I like to flesh it out, and of course the Supreme Court has totally neutered this in decisions ranging back to 1985, but currently the current Supreme Court has basically neutered a lot of the Fourth Amendment protections that we have. But I always like to argue it this way. Probable cause, and it's going to sound infantile, so bear with me here, but it makes sense. Probable cause is the locomotive that pulls the train of search and seizure. If you're going to have searches under the Fourth Amendment, you must begin with probable cause. That's your locomotive. You cannot push search and seizure with the locomotive. Understand? What must come first is probable cause. Now, the problem is the Supreme Court has now allowed police to assert a form of probable cause after the fact. That they should have had probable cause at the time. They might not have had it, but the search isn't illegal because they should have had it. The minute you start this slippery slope, the entire Fourth Amendment is all but emasculated by the Supreme Court. But for our purposes, we have the search and seizure syllogism, and I hope that little child poem there helps you along the way. Okay? Obviously, arrest. They can arrest you, but at the time of the arrest, and we'll talk about that later, you must be given your Miranda rights. Obviously, that's also been emasculated by the Supreme Court in recent decisions. Okay, but in terms of search and seizure, what can be searched? Now, on the street, you could be searched. You could be patted down, and that's a key issue now. You notice, I think there was a Buccaneers game just yesterday, or today actually, the court ruled that the pat-downs are illegal. The Patriot Act allows for a lot more police investigation on street corners and the like, or suspicion and the like. So, you have wherever you have no expectation of privacy. The argument goes that on the street you have no expectation of privacy. Any place you have an expectation of privacy, you must be asked whether you will consent to the search, or a warrant must be presented. A specified warrant must be presented to you that allows for that probable cause of the search. A warrant is no more or less than written down probable cause. Just remember that, especially as you take criminal justice courses. Remember that a warrant is no more or less than written down probable cause. Okay? And we all know it's the locomotive that pulls the train of search and seizure. All right, Fifth Amendment. You have a right to say nothing if questioned. Okay? Because, again, it places the burden on the state to be the moving party. Okay? So your Fifth Amendment means that you have a right not to give testimony. And the way to secure that years ago was the case of Miranda, where he was questioned after arrest, and that material was used against him in a court of law. Now, with the Miranda being weakened by the Supreme Court, you have to make sure, if arrested, you do not say anything. Wait until you get an attorney. Okay? But we all know the Miranda warning. You know, one will be provided for you, yada, yada, yada. Okay? A couple other issues that we find with Fourth Amendment is pretrial identification. This is a typical topic of contention. Were you properly identified? There were cases right up until recently where you had, for instance, the victim said the perpetrator might have been of color, quote unquote, of color. And lo and behold, we've got 4 white guys in a police lineup and 1 black guy, right, that they want to convict, in a sense. Obviously, that is an improper police lineup. Okay, so pretrial identification becomes an issue if you're presented with photographs. Do the police give you indicators of certain photographs? That could be an invalid pretrial identification. Okay, and of course the right to bail. The idea of bail is the right to be given release time to help with your defense. Obviously, if you've committed a crime that is so heinous or you're likely to repeat again, you'll be denied the right to bail. But the right to bail is a legal right, which can be granted. It's it's more than a privilege, but it's less than a solid right. It can be denied if you're likely to flee. But a right to bail is the right also to defend yourself, in a sense, to assist your counsel. It's easier for you to assist counsel if you're unlikely to flee or repeat before the trial by being out in the community to help the counsel in your defense. Okay. It's just some basic criminal procedure rights, and I've listed them out here for you. Many of these you're familiar with. Many of these you'll be able to do in other courses and the like, but here are some of the typical criminal procedure rights. The right to a speedy trial. Put quotations around speedy. Because that is really a question of how fast the legal system can process the case involved. But denial of, for instance, the Guantanamo Bay, it's obviously denial of counsel, but also denial of speedy trial. They're being held without a trial being held at all. The right to an unbiased judge. I don't think anything else has to be said. You have a right to an unbiased judge. In some cases, you have a right to a jury trial. Any penalty that are 2 or more years, you have a right to a jury trial, and that's now considered a fundamental right. After the case of Duncan versus Louisiana, that's now considered a fundamental right. And that becomes key because you want to be judged, in some cases, by your peers. In other cases, you don't want to be judged by your peers. It'd be better to have a judge-based trial. You have a right to counsel, right? You have a right to counsel when being questioned. You do not have a right to counsel upon arrest, right? So bear with the police, cooperate, do not say anything. Wait until you have that right to counsel. You do not always have a right to counsel. If you're arrested, put in jail, right, and questioned, you have a right to counsel being present. You also have a collateral attack on your arrest, and this is known as the prisoner's petitions usually, or habeas corpus. Habeas corpus is a typical criminal procedure argument. It literally means free up the body, preferably living, obviously. But it's a collateral attack on the state's rights to hold you. So criminal appeals are typically done through a petition for habeas corpus, saying that the state does not have a right to hold your body. Okay, to free up you, okay, for retrial. Okay, obviously we've sometimes heard of double jeopardy. This is being charged twice with the same crime based on the same facts. Now, double jeopardy is strictly enforced if you have new facts that were not available to counsel, and available means after a diligent search they were still unavailable at the time. Then in times the court will allow for another trial or a retrial. But typically double jeopardy protects society from the state always having a case against you. You're always running around in fear that you might be prosecuted at any time. Right to criminal appeal we talked about slightly. That's all we need to know right now. That typically you have a right to a criminal appeal in terms of death penalty cases. You have a right to 2 or 3 appeals. And that's usually set by jurisdiction. And finally, the Fifth Amendment self-incrimination prohibition. That's obviously you have the right to remain silent. Okay? Again, that assures that the criminal procedure, the burden sits with the state and rests with the state. That if the state wants to find you guilty, they're the ones that have to prove it, not through your own self-incrimination. Well, I hope this helped. You'll be able to listen to it a few times if you want to go through the various civil and procedural issues and motion practice and the like. If you have any questions, obviously feel free to contact me and I'll be able to talk to you more about it. So I hope this helped. You have a great day, night, whenever you're listening to this. Bye for now. Oh yeah, and by the way, this is where you're going to school.